Well, welcome. My name is Brian Brannon, and it is my pleasure to chair the Central Organizing Group of the Chartered Institute of Arbitrators Young Members Group, ADR World Tour, Arbitration and Mediation as a Global Force for Good. Over the course of the next few weeks, we'll have 11 regional webinars taking place across the world, which focus on ADR and access to justice, ADR as a means to strengthen the rule of law, and ADR as an efficient alternative to traditional litigation. In particular, during this time of pandemic, we're interested to hear about how ADR is assisting your judiciary, your culture, and your economic recovery as we work together 6 feet apart. It is my pleasure to welcome the Cardozo School of Law and the Korean Commercial Arbitration Board as global sponsors, and in particular, the leaders of the Asia World Tour, my friends and my colleagues, Ishan Madan, David Chung, Kirsten Teo. Without the Central Organizing Group and the ADR World Tour's Asia leadership, none of this would be possible. In particular, it would not be possible without the Korean Commercial Arbitration Board and the Cardozo School of Law as global sponsors, but additionally, our numerous collaborating organizations throughout the world. If you're not currently a member of the Chartered Institute of Arbitrators, I encourage you to join. I serve on the North America Branch Board of Directors and its Young Members Group Steering Committee. We're also delighted to have the support of the Singapore, Malaysia, and East Asia branches of the Chartered Institute of Arbitrators, a not-for-profit organization consisting of 16,000 members in 147 countries. Thank you for attending today's leg of the Asia World Tour. At this time, it is my pleasure to hand the microphone over to Ishan Madan.
Thank you so much, Brian, and thank you so much, everyone. Ladies and gentlemen, welcome. Good evening to our friends and colleagues in Asia, and good morning and good afternoon to everyone else from around the world. We hope that you are all well and that news of vaccination is bringing in our respective communities some kind of comfort. As things get better in terms of the pandemic, we are likely to see an uptick in disputes. And here we are to discuss ADR as a global force for good. Today is a big day as we inaugurate the ADR World Tour, the largest, longest series of ADR events. The world is looking at Asia for very many reasons, and it is only ideal to begin the World Tour from Asia. Might I mention that given the enormity of other markets, there will be separate series of events for India and China respectively too later in the months. So stay tuned for that. But before we move to our awesome panelists, I would first like to begin with some housekeeping suggestions. All of the attendees are requested to use the Q&A tab on the bottom of your screen to share your questions instead of the chat, please. In the chats, though, do drop in a hello mentioning where you're from. Questions will be taken up towards the end of the discussion. During the event, you may also see some poll questions popping up on your Zoom screen. Please feel free to answer all those questions with anonymity. The good thing about those poll questions will be that you will be playing a part for us in developing a comparative study of all the regions and continents as we cover them over the course of these 4 months. Must I also point out as a disclaimer that the views shared by the speakers and panelists today may not necessarily reflect the views of any organization, entity, or firm that they may be associated or affiliated with or they represent. The views may only be academic for the purpose of discussion. Anything discussed here shall not be attributable to any related organizations, unless, of course, the speakers are speaking in that capacity and desire and indicate so. Thank you so much for bearing with those mandatory announcements. But now, without further ado, allow me to introduce the esteemed people on screen. We have with us representations from 5 different countries and 4 different arbitration institutions. First off, Tahi An is a counsel at the Korea Commercial Arbitration Board International, KCAB International from Korea. He completed his doctorate course in international law, including investor-state arbitration, and is quite active in the international arbitration circle in the continent. We have Victoria Khandri Milo with us, a counsel from HKIAC. She holds an LLM in International Disputes Resolution from the coveted MITS program, and she's here to talk to us about the HKIAC and its practices. Next up, we have with us Sajjad Ahmed. He's a dual qualified lawyer, licensed both in New York and in Pakistan, having almost 2 decades experience of practicing law in both these countries in areas including contracts, cross-border transactions, commercial litigation, and domestic and international arbitration. He's also the founder and president of the Center for International Investment and Commercial Arbitration, Sika, which is the first in his country. Next up, we have with us Mr. M.A. Akmal Azad. He's the director of Bangladesh International Arbitration Center, and he heads the training and outreach wing of BIAC. A formal additional secretary to the government of Bangladesh, he's the primary contact point of BIAC for capacity building on ADR. He's been a constant advisor to the legislator in bringing reforms to ADR in the country. And last but not least, my friend Diogo Pereira. Diogo is an international lawyer specializing in international arbitration, public international law, and investigations relating to corruption, money laundering, sanctions, and terrorist finance. Based out of Washington, D.C., he has significant experience in Latin America, Europe, the United States, and Middle East. So thank you very much. Thank you to all of you. I would like to give a big round of applause, and I'm so excited as we kick off this ADR World Tour. Now, as we move forward, we're going to divide this discussion into 3 segments. In the first segment, which we are about to begin, I will invite the speakers from all these respective organizations to talk about their organizations, the kind of work that they've been doing. We are about to embark on a journey starting today to know about these arbitral institutions and those around the world. And despite the differences in their size and the workload, they represent avenues of and opportunities for effective dispute resolution in their domestic markets as well as in their regional international markets. Now, to move on with that, let us first hear firsthand from Tahi An from Kcab. Tahi, in no more than 5 minutes, I request you to please tell us more about Kcab and how you've been dealing with the pandemic.
Thank you, Ishan. I'm pleased and honored to be part of this webinar series hosted by CIArb Young Members Group. Without further ado, I will briefly introduce my institution, the Korean Commercial Arbitration Board, significant changes made in my institution over the past years, and the way how we responded to the global pandemic. As the sole institution that offers comprehensive ADR services in Korea, Kcab has been providing arbitration and mediation services since 1966. To enhance its international capacity, Kcab launched Kcab International in 2018 as its independent division for managing international arbitration cases and promoting international arbitration. Users of Kcab International's international arbitration service represent various countries and continents. Besides Korean parties, US, Vietnam, China, Japan, and Indonesia were the top 5 nationalities of its users in 2019. Its international arbitration service is well known for its time efficiency and lower costs without sacrificing its quality of service. Kcab International also hosts various events, including the annual Seoul ADR Festival Week taking place around November. It has also been hosting the Asia-Pacific regional rounds of the FDI Moot every year. And this year, it will be hosting the global rounds of the FDI Moot in November, from October to November. Moving on to the key updates of my institution, one of the most significant changes recently made in Kcab was the launch of Kcab International in 2018. Basically, Kcab International is a quasi-independent international wing of Kcab. Structure-wise, it is under the umbrella of Kcab, but it operates independently. It is led by the chairman, Professor Hee-taek Shin, and the Secretary General, Ms. Soo-hyun Lim, both highly esteemed figures in the global arbitration community. Based on their vast experience in international arbitration as a lawyer, they have been greatly contributing to improving the Kcab International's arbitration case management services. We have an international team of case managers admitted to practice in South Korea, New York, Washington, D.C., and New Zealand. Their case management service have become well recognized globally by arbitrators and counsel. Kcab International has also expanded its panel of arbitrators. Now we have more than 500 arbitrators on our panel from all over the world, representing both civil law and common law jurisdictions. Besides South Korea, US, UK, China, Germany, and Singapore are the top 5 nationalities of the arbitrators. It includes globally well-renowned names as well, such as Ms. Judith Skill QC, Professor Bernard Hanotiao, and Mr. Gabyu Kevin Kim, all of whom I had the honor to work with as a case manager. We have seen a steady increase in case numbers throughout the past years. In 2019, Kcab has seen more than 30% increase in international in arbitration cases compared to 2011, from around 300 cases to over 440. We also have annually handled hundreds of court-connected mediation cases. To meet the demands of our users, Kcab also opened its overseas offices in 2016 in LA and Shanghai, respectively, and more recently in Hanoi in 2019. Consolidation of Seoul International Dispute Resolution Center with the Kcab is also worth mentioning. In 2018, Seoul RDRC was merged with Kcab. Its hearing facilities were relocated to Gangnam District, expanded at 3 times its previous size, and fully refurbished with new equipment and facilities. Since the consolidation between the 2 institutions, Seoul RDRC has been gaining more and more popularity in the international arbitration community. In 2020, the number of hearings conducted at Seoul RDRC that were administered by other institutions than Kcab increased by 60%. In terms of Kcab's international arbitration rules, recent updates were made in 2016 to reflect the trends and best practices in international arbitration. The amendments allow for submitting documents in electronic format. The rules also introduce new procedures for arbitrator screening, procedures relating to multiple parties and multiple contracts, such as joinder of additional parties and consolidation of claims, and procedures relating to the emergency arbitrator, among others. Furthermore, in the wake of the Singapore Convention on Mediations entry into force in the last year, Kcab has begun the process of making mediation rules specifically tailored to international disputes. Lastly, Kcab responded very swiftly to the global pandemic caused by COVID-19. First, Kcab International circulated an announcement that its case management capacities were operating as normal in March 2020. The case managers informed the arbitrary tribunals that virtual hearing could be an available option, as Seoul RDRC was fully equipped with the required facilities. And in relation to that, Kcab International officially released the Seoul Protocol on Video Conference in International Arbitration in last March to provide a useful guideline in conducting virtual hearings to the global arbitration community. Furthermore, the trade tower where Kcab and Seoul RDRC are located installed a thermal camera and placed hand sanitizers before entrance of the building. Frequent and thorough sanitization has been conducted throughout the building. So thus far, there has been no lockdown of Kcab's operation. Seoul RDRC was also very prompt in responding to the COVID-19. It has kept updating its facilities to offer up-to-date virtual hearing experience. The number of hearings conducted by Seoul RDRC's virtual hearing services increased by 500% between 2019 and 2020. That's all I've got to say for now. Thank you very much for listening.
Wow, thank you so much, Tahi. That was quite impressive. And of course, the things Kcab is doing, as well as to hear about the Seoul Protocol. Next up, I invite Sajjad Ahmed to please talk about the developments happening in his country. And of course, more importantly, what Sika has been doing.
Thank you, Sean. I'd like to thank you once again for this opportunity, CIArb, which is hosting this conference. Of course, I could talk about Sika for a long time, but I'll make sure I keep it at less than 5 minutes. So Sika was established back in 2015, about 6 years ago. And I think before I talk about what Sika does, I think it's important to know why Sika was established. So for me, it's been a passion project from the very outset. And I think my primary motivation for setting up Sika was this glaring lack of awareness of international arbitration in Pakistan. I used to watch news stories on television. I used to read news reports in the newspapers about how the state of Pakistan was doing in the international investment arbitration cases. And it was very frustrating to see how people did not have a clue as to how international arbitration works. I used to write some op-eds in newspapers. Then I realized, writing op-eds only goes so far. So I thought about setting up an institution where we can have discussions on relevant issues. And the idea basically was initially to raise awareness of international arbitration in Pakistan. So we started in 2015, and when it was set up, we didn't have a panel of arbitrators. We didn't have our own arbitration rules. The primary purpose was to organize conferences, conduct training workshops, to build capacity. But a year after it was launched, we had our own rules. We set up a panel of arbitrators, like a traditional arbitration center. Now, what has Sika done since its establishment? Of course, we've organized several groundbreaking conferences. And I say groundbreaking because the number of foreign speakers who've flown into Pakistan just to attend Sika's conferences, it's very reassuring for me because there are people who have come to Pakistan for the very first time just to attend the Sika conferences. So in that sense, Sika has sort of put Pakistan on the map because people get to know about Pakistan's legal landscape, how things are in Pakistan. So it's not just about Sika when they come to Pakistan. In terms of the topics of the conferences, of course, we focus on the relevant cases in which the government of Pakistan is involved. We have also focused on the Belt and Road Initiative. The Pakistan component of that is called the China-Pakistan Economic Corridor. And Pakistan, there's a lot of excitement about CPEC because people think that it is a game changer, which I agree with. So we focus on that as well with a view to figuring out what the dispute resolution mechanism should be. So that's been our focus. And a lot of people think that, talk is cheap. I personally believe that change happens one conversation at a time. And I think because of these conferences, we believe that we have sort of raised the level of understanding of international arbitration in Pakistan, which would hopefully hold Pakistan in good stead in the future. In terms of capacity building, we've organized a few workshops as well at leading universities in Pakistan, at the Lahore High Court, at the Pakistan Engineering Council, and most recently at the Punjab Judicial Academy. Now, Punjab Judicial Academy is an academy for training judges. So thankfully, recently, the government of Punjab, which is one of the provinces in Pakistan, they set up these commercial courts. So we were invited to conduct a training workshop for the commercial court judges with the focus on domestic and international arbitration. So Sika has been involved in that sense, various segments of society to build capacity. One of the other objectives of Sika has been legislative reform in Pakistan. So to put this into context, Pakistan's Arbitration Act is titled Arbitration Act 1940. So Pakistan was created in 1947. The law that we have is basically a colonial holdover from the British. Unfortunately, we haven't updated it yet. It's been like 80 years now. So that's one thing we would like to change as well, because for an arbitration center to thrive in a country like Pakistan, and for arbitrations ultimately, sounds ambitious at this point, to be seated in Pakistan, we need to have, of course, we need to enact the Untitled modern law, and more importantly, we need to update our domestic law as well. So that's one thing Sika is working on as well. And to that end, last year, about 5 months ago, Sika formally launched its Legislative Reforms Committee, which is chaired by a leading international arbitration practitioner and comprises other international arbitration practitioners as well. So we're working on a legislative reform as well. Now, in line with the theme of this conference, in the post-COVID-19 world, so one of the things Sika did was we launched our own online dispute resolution services. Now, to the outside world, this seems fairly standard, right? ODR, it's fairly common. But in Pakistan, this was something that was not being offered. So when the courts shut down, there were delays. There was no ADR center as such, which was offering online dispute resolution services. So Sika stepped up, and we realized that there's something we need to do. So that's one change we made. What we also did was, again, I think this is in line with the theme of this conference, how ADR can be a force for good. I've always believed in doing good and doing well. So I think I'm very happy to share that what Sika did was, so for our expedited arbitration services, we discounted our fees by about 40%, which is a substantial discount. And what we did was that we raised the limit for the subject matter of the dispute. So initially it was 500,000 USD for expedited arbitration services. We raised it to 600,000 USD. The idea was to accommodate as many micro, small, and medium enterprises, MSMEs, so to speak. So because, after the COVID-19 happened, there was a lot of financial distress that companies experienced, especially the smaller players. So we thought that this is a small part that Sika can play in the post-COVID-19 world. So those were some of the changes. And I think Sika would continue to sort of work to achieve its ambitious objectives. Of course, I call it ambitious because it's a fairly diverse set of objectives that we're trying to accomplish, because in a country like Pakistan, where arbitration is not commonly adopted, except for a couple of sectors, so we have a lot on our plate. So that's why when we started out, we realized that in addition to just offering services, capacity building and legislative reform are key steps that we need to take. And so it's been 6 years. It's been a rewarding journey, but we hope to continue doing what we've been doing. Thank you.
Sorry, it's the theme of 2020. I'm on mute, or you're on mute. Sorry. I'm saying it's amazing. Thank you so much for sharing that. And yeah, what I'm contemplating is that it's amazing how the will of one person to build capacity, to create awareness about a certain field of study, and to educate can pave the way for, actually, when we are talking about ADR as a force for good, and that's what you're doing. So it's amazing, and congratulations to you on that, and the measures taken by you during the pandemic. Now, moving on, I now invite Victoria Khandri Milo from Hong Kong International Arbitration Center. Victoria, the stage is yours.
Good evening to the speakers from Hong Kong and to all the audience around the world. Ishan, thank you for your kind words and invitation to speak today at this pioneer event at the ADR World Tour, which I for sure think will be of great success. For the time I have, I will briefly present the developments, the trends, if we say so, that we see at HKC. I would like to share the screen. Yes. So first of all, I would like to briefly say some words about HKC. HKC has been founded in 1985 and today has managed over 11,000 dispute resolution matters, which comprise of arbitration, mediation, domain name, and adjudication. And in 2020, we see a record year in terms of arbitration submitted to HKC, and the number is 318. First time we went over 300 was 2019, and this year we kept at 318, and the full comprehensive official report on our statistics will be published at the end of January at our website. And 203 out of 318 cases were fully administered arbitrations as opposed to ad hoc arbitration. And this is the trend that we see in our services, that there is a growth in the fully administered arbitration versus the ad hoc arbitration. The next development that I would like to mention is connected to the point that HKC is the connecting point for the Chinese and non-Chinese parties, and the mainland Chinese parties remain the top users of HKC services. And in this vein, I would like to speak to the interim measures arrangement that was entered between the Supreme People's Court of the People's Republic of China and Hong Kong government in April 2019. And under this arrangement, HKC is one of the 6 qualified institutions. Pursuant to this arrangement, a party to the arbitration seated in Hong Kong and administered by HKC may apply to the mainland Chinese courts for the preservation of the assets, conduct, or evidence. And this arrangement is unique to Hong Kong because Hong Kong is the only jurisdiction outside the mainland China where the parties can obtain interim relief from the mainland court. And here on the slide, you can see some figures on the application that HKC has processed so far from the October 2018 when the arrangement came into the force. And I would like to mention that this arrangement is described as groundbreaking, since this is the first legal instrument the mainland China allowed, where mainland China allowed its courts to issue the interim measures in support of the arbitration seated in Hong Kong. And if we speak today about the trends that we see, we can say that this development demonstrates the step that the mainland China takes towards internationalizing its practice. And to conclude, I would like briefly speak on the HKC response to the parties' needs to hold a hearing given the COVID-19 restrictions. So in HKC practice, we saw 2 approaches through 2020, and the first approach of the parties and tribunal was in early days when the parties chose to postpone or cancel the hearings, and we saw a shift in late February and March when the tribunals opted for having hearings virtually, fully or partially, and this has been a significant shift. And we can see that most of the hearings held in HKC in 2020 have been virtual. On the slide, you can see that it amounts to 68%. And these trends also can be seen at the beginning of this year. The 50% of the bookings we have now also require some virtual hearing services, and the hearings, the complexity of the hearings also varies from a simple procedural to the fully merits hearing. And I think this is all for the developments from HKC side. Thank you.
Thank you so much, Victoria. That was quite informative. And it's a request to all the other speakers as well that as we move along, please do share about any um, procedural challenges that exist in your jurisdictions regarding virtual hearings and how, given that they're increasing. Next up, I'm going to invite Mr. Azad. And before I invite him, we will just take a 10-second break perhaps in between, and I will raise a poll question for you to please respond. All the attendees, please note that you can respond to these questions with anonymity. Nobody will get to know what you answered. But yes, it will definitely help us understand how things are progressing in your respective jurisdictions, regions, continents. So here's the poll question. But while that poll question happens, may I now invite Mr. Azad, the director of Bangladesh International Arbitration Center, to talk about how arbitration has been developing in Bangladesh and where Bangladesh is seeing ADR in the near future. Mr. Azad.
Hello everybody, without regard to morning or evening. Bangladesh International Arbitration Center, BIAC, in the wake of COVID-19 has to respond more to the alternative dispute resolution ADR programs with concern for the health of the parties coming up for arbitration and mediation. This may be a good time for us to use online platforms such as Zoom or other video conference options to conduct ADR sessions. As the country's first and only registered ADR institution, we understand how important access to justice is, given the backlog of nearly 3.8 million pending cases in all types of courts in the country, and BIAC has a crucial role to play in delivering the same, especially during the current hard time. We at BIAC placed to serve our patrons to the best of our abilities and will continue to do so as we are steadily getting attuned to the attention of the financial and corporate sectors, as well as the educational institutions and the legal fraternity, to the advantages of ADR sector, ADR mechanisms. ADR is a crucial need for expanding the influx of foreign direct of Bangladesh in the World Bank's Global Doing Business Index. In order to achieve the sustainable development goals to which Bangladesh is a signatory, in addition to keep up with the international best practices around the world, Bangladesh needs to develop a strong ADR framework so that it can coexist with the judicial system. How BIAC emerged? It is the business organizations, the International Chamber of Commerce Bangladesh, the Dhaka Chamber of Commerce and Industry, and the Metropolitan Chamber of Commerce and Industry established BIAC back in 2004, taking license from the government, and actually it took a few years for BIAC to start operation back in 2011. The government of Bangladesh is a signatory to the UN Convention on the Recognition of Enforcement of Foreign Arbitral Awards 1958, commonly known as the New York Convention. We have the Arbitration Act of 2001, which is based on the international trade law, or the popularly known as the Ancestral Model Law, the Bangladesh Energy Regulatory Commission Act 2003, the Real Estate Development and Management Act 2010, have arbitral provisions, and we have a number of laws which has provisions of arbitration, mediation, and negotiation. To talk about our facilities, we have our own arbitration rules, which have been recently modified and made user-friendly. We have a panel of arbitrators comprising 11 eminent jurists, of whom 4 are former Chief Justices of Bangladesh. We have all the facilities to handle arbitration cases and hearings. So far, we have handled 109 arbitration cases, and we have already launched membership to practitioners, stakeholders, and interested individuals to create a knowledge and resource sharing platform. It will enable all interested parties to enhance individual knowledge and contribute towards enriching the ADR landscape of the country. Currently, there are 41 national and 6 international members of BIAC. So far, since 2011, we have 128 cases and 306 arbitration and mediation hearings in total. About training programs, we have our core activity includes training programs for lawyers, academicians, government officials, corporate entities, banks, financial institutions, officials from different agencies, and students and academicians. We have recently started training government officials, including senior assistant secretaries from the Ministry of Law. We have also training stakeholders from different agencies jointly with our partners like Thailand Arbitration Center and our partners in India and Singapore. Statistically speaking, we have from 2011 had 71 training programs where around 1,700 participants attended from different government organizations, banks, and corporate houses. We have outreach programs from 2007 till now. We have 132 seminars, webinars, workshops, and we have tried to highlight how we can help our stakeholders build a human resource base by raising awareness among them. And so far we have around 132 such programs. We have been recognized nationally by signing agreements with 28 national entities like universities, banks, corporate houses, law chambers, NGOs, etc. And internationally, we are recognized by 18 international ADR centers, including the Permanent Arbitration, Thailand Arbitration Center, Singapore International Arbitration Center, the SARCO, Vietnam Arbitration Center, AISC of Kuala Lumpur, and so on. We have a publication, the BIAC Quarterly Bulletin, which is the only dedicated news bulletin on ADR, which is published from Bangladesh. It depicts BIAC's achievements, publishes international news on ADR, article by eminent contributors and experts on ADR, and interviews of lawyers, bankers, corporate managers, and academicians on how they look at issues and prospects of ADR in their respective fields. Print copies of the bulletin are distributed locally among stakeholders. It is circulated on BIAC's website and social media platforms. Government, a former Chief Justice of Bangladesh, is working on amendment to the Age-Old Arbitration Act 2001. They invited BIAC to give opinion on proposed amendments to the Act. At a consultation session organized by BIAC on 28 October 2018, speakers including judges, lawyers, bureaucrats, and business leaders focused on an user-friendly arbitration act to attract more foreign direct investment to Bangladesh, contributing to overall development of the economy. Taking part in the consultation session, experts elaborated how Bangladesh can be one of the top seats of arbitration in Asia by 2028. They also opined that the proposed amendment to the Act would help Bangladesh grow as a neutral, accessible, predictable, and balanced seat of arbitration, where disputing parties from different nationalities will feel comfort to arbitrate commercial disputes. During the consultation session, BIAC gave some specific observations and suggestions towards amendment of Arbitration Act 2001. For time constraint, I must end up here. Thank you, everybody, so much.
Thank you, Mr. Razad. And again, clearly, a lot of capacity building exercise is being carried out by BIAC, and the efforts you are doing and putting in to actually bring in ADR as a more accessible tool for the users in Bangladesh, which is great. And for everyone who's joining us now in between, let me just tell you, this is the first of the series, the ADR World Tour series that's happening under the CIArb YMG Young Members Group. And we are talking today about the emerging trends in arbitration in Asia. Now, while as of now, we understood from the perspectives of different representatives what the institutions are doing in the continent, but now it's about time that we move on to the West to understand how the West is looking at Asia and the expectations. For that, I invite Diogo Pereira to discuss with us the perspectives on Asia, to talk to us about trade and investments, how the world is looking at Asia in the future, and where does international dispute resolution finds its place, whether it's going to be of primacy in arbitration or mediation. The convention that took birth in Asia, where does it find itself in the near future? Diogo.
Well, thank you, Ishan, and thank you to all of the panelists. As Ishan mentioned, I'm here based in Washington, D.C., and that gives me, on one hand, less familiarity with maybe some of the things on the ground, but the luxury of being able to provide a more overarching view. And another thing here in D.C. is that we tend to focus a lot on investment arbitration due to ICSID's facilities here and the general proximity to the United States federal government. And one thing that I wanted to point out is that, you know, we've recently been speaking about commercial arbitration, but in the context of investment arbitration, there's a much greater lead in time. So for example, in a commercial arbitration, you might be thinking about emerging trends over the last 6 to 18 months. In investment arbitration, you generally would be looking at 5 years or longer. And this webinar and this series, we talk a lot about ADR as a source for good in the world. And I think with investment arbitration is a place where we can see that very clearly. Just, you know, to humor me with a little bit of background, investment arbitration actually has its roots dating back to the Caribbean in the turn of the century. At that time, you had lots of disputes between private companies and states that would be resolved by gunboats. So one of the classic examples was the British driving a gunboat outside of Venezuela in 1905 in order to mediate or negotiate. So obviously that wasn't a very even-handed or friendly type of negotiation. And that was actually one of the reasons that investment arbitration was brought in, was to find a peaceful way of resolving these sorts of disputes as opposed to resorting to guns. Fast forward to the present, I think everyone here would agree that we're much more likely to see gunboats making movements in the South China Sea than we would in the Caribbean. And also nowadays, I think you know, people would probably take a Chinese gunboat or an American gunboat more seriously than a British one. So, I mean, the world is truly a different place, and the lessons of investment arbitration are more applicable to Asia than they ever have been, and I think will take on increasing relevance. Aside from these more dramatic shifts, you see in the last 50 years a huge development of the economy and trade in Asia, and not only in terms of inbound investment, which has multiplied dramatically, but also by outbound investment. So now you see Chinese investors very active in South America, in Africa, same thing with Japanese or Australian. You see a lot of outbound investment, and that certainly has shifted the approach in many jurisdictions. So, I mean, in the last few years, you've seen not only I mean, when I say few, in the last 50 years, you've seen a proliferation of BITs that's been dramatic from the 1970s through 2010. And recently, you've seen a number of Asian investors bringing ISDS claims. So as of about a year ago, there was at least 6 publicly reported investor state claims brought by Chinese investors, 7 by Singaporean investors. And of course, on the respondent side, you've also seen a proliferation. And looking at Asia as a whole, when we talk about investor-state dispute resolution, it's a bit of a mixed picture. So we've heard all the panelists talking about, you know, the increase in commercial arbitration in Hong Kong and Bangladesh and Pakistan and Korea. With investor-state arbitration, it's not the same sort of linear increase where everywhere you look, people are taking to it the same way. A number of Asian states have been respondents in investor-state cases, and you see that most notably in places like Indonesia and India. And just to call on Ishan, I mean, Ishan, can you tell us just in a few sentences about the reaction in India to the White Industries case?
Well, I'll just briefly say they wouldn't, like, okay, that's how it happens. It's not like, you know, you were deprived of anything. That's how it moves. It takes about 10, 20 years for resolution in courts. I mean, that was the case, but then things have changed since then. To address those issues, they came out with the model BIT. And right after that, they came out with the India-Brazil BIT, which kind of goes back again to gunboat diplomacy.
Yeah, so I mean, in the White Industries, the point that I really wanted to make is that after that, India dramatically changed its perspective to investor-state arbitration. Instead of saying this is always good, it was more of an approach, maybe we need to think about this carefully, how to make this work for us. Similarly, Australia, after being presented with the Philip Morris disputes, has dramatically taken a different approach because it is concerned about health and safety and the way different things will be interpreted and the sort of liabilities it's exposing itself to. So as much as I'd like to generalize and say everything in Asia is monolithic, it's clearly not, right? And in the investor state context, that's very clear. And next week, I know we have another panel on this world tour about the reforms of investor state arbitration. So we're not going to go into that too much today, but suffice to say that there have been dramatic changes. And as Sajjad mentioned, I mean, a lot of this also is related to the Belt and Road Initiative and the general outbound investment that we're seeing across the region and across the world, really. So, but regardless of all of that, one thing that we have seen quite clearly is a renewed interest in multilateral approaches. So we're seeing a lot more multilateral agreements as opposed to individual BITs. You can see that with just last month, the Regional Comprehensive Economic Partnership was signed, and that doesn't actually have a typical investor state mechanism. It has more of a state-to-state type mechanism for dealing with disputes. And in addition, we've also seen, for example, ASEAN over the last 5 years has its internal investment ISDS system, but it's also negotiating treaties as a bloc with other countries. And so we've seen that that developing quite clearly. Aside from that, there's been a number of very interesting developments in specific jurisdictions. So again, Sajjad mentioned, the need in Pakistan to adopt a UNCITRAL model law and those domestic developments, but in other regions, such as in Hong Kong and in Singapore, we've seen the adoption of third-party funding, which is a recent development and will dramatically change the landscape and eventually lead to an increase in investor state disputes. Additionally, and Victoria, maybe you can comment on this a bit more, Singapore and Hong Kong and other institutions, including the Korean Center for International Arbitration, have set out rules for investor state disputes. And we're starting to see slowly those being adopted. So I know Victoria mentioned that there's 2 current ISDS cases. Is that correct, Victoria, in HKs?
Yes, Diogo, this is correct. So far, HKC administered 2 investment arbitration. I would just comment that these cases arose, one of the free trade agreement, the other from the BIT, and the rules that have been used in those cases are UNCITRAL rules and administered under the HKC procedures, which is specifically designed to administer arbitrations under UNCITRAL rules.
Thank you for that, Victoria. So, I mean, we see, this is, I have a sense from Washington and talking to our clients and observing the things on the ground that we're on a cusp where there's been building interest, building institutional development, and a building capacity and knowledge base surrounding these issues that are going to lead to an increase in that. And Ishan specifically spoke to us, mentioned the question about mediation. There is the Singapore Convention now on the enforcement of mediation, and mediation, for a number of reasons, both historic and some would say cultural, has been looked upon quite favorably in Asia. And so I certainly think that mediation will be an important part of the picture in the future. One thing I would just caution is this idea, of the gunboat diplomacy again, is when you have a mediation between 2 parties that are not nearly equal in terms of bargaining power, mediation can be a way to conceal, the powerful pushing their will on the less powerful. So that's something that we've seen a number of clients having disputes with larger nations, and these are investors, and of course the larger nation wants to mediate because it's an easier way for them to impose their will. And the truth is, we have to remember that the law is at its best when when justice is equally applied to all, and it provides a mechanism for weaker parties to have a fair share and a fair hearing. So, I mean, I think it is going both ways, and mediation is very useful in the commercial context and will always be useful in the investor state and state-to-state context. It is not always it's not an even substitute always for mediation. for a firm dispute resolution. So that's something that I think is something worth watching and something that we should all be aware of. And just the last point that I want to make anecdotally is that in terms of our clients and our interactions, we're seeing a lot more attention being paid to investor state protections. So that means even at the stage of structuring investments, a lot of countries are doing a due diligence on the treaties, and a lot of countries, a lot of investors are doing the due diligence on the treaties available to them and specifically structuring their disputes so they can avail themselves to those protections in the future. So it's really just a matter of time before this increases. And I think everyone's seeing that trend. It's a slow moving trend, but it will go there, it will get there. And I'm sure we'll see a continued discussion about how to modify the investor state system and how to redefine terms and protections and carve outs and appellate mechanisms. All of those things will continue to be discussed, but I think given the increasing relevance of the Pacific in international trade, and it's inevitable. And one thing that just to piggyback on what Sajjad was mentioning in terms of the costs of his center, there is also a democratizing force in the sense that as technology develops, costs will be reduced. So it will make arbitration available to more people, to smaller businesses, and it can really operate as a force for good. And I think that's a trend that we're all seeing in terms of increasing the availability and access to justice for not only large investors, but to smaller ones as well. So those are just some, taking a bird's eye view of the region and focusing a bit on the investor state context are things that we have seen. And so with that, Ishan, I think I'll pass the floor back to you. I mean, there's a lot of interesting things to talk about in terms of technology disputes and other movements, but I'd like to pass the baton back and to all my distinguished colleagues.
Thank you so much, Diogo. Yes, there's so much ground to cover here, and precisely why we are going to have 3 more events over the course of the next 36 hours. So, I'll request the attendees to keep following on that, because everything that we are discussing here will eventually be discussed in more detail in the events to come. And one important thing, Diogo, that you mentioned, vis-a-vis the white industries versus India case also, till the time you're at the receiving end, you don't understand those things. So many countries, we do enter into conventions and treaties and bind ourselves at some level or the other, but how to address those things, unless and until you're in the situation, you do not get to learn how to deal with that. India now has, for example, revoked 58 of its treaties, and they're all in their sunset phase. Right now, there are about 14 treaties, out of which 7 or 9 are still in their incubation phase. They've been signed, but yet to be ratified. And I'm pretty sure Pakistan has been at the receiving end of certain awards. Some we hear that are on the verge of being settled or adjudicated. Korea has been in the news recently. Bangladesh has been on the receiving end of awards. From Hong Kong, we had the Philip Morris versus Australia case. So I invite our speakers to, before we move to other things, there's so much to discuss. We have to discuss about third-party funding, what's happening on that front. We have to talk about amendments that have taken place during the course of the pandemic to pave way for better ADR procedures. We have to discuss about, one interesting thing that I have to ask Tahi about is dispute resolution of IP, of intellectual property matters. But before that, I invite our speakers to talk about changes that are taking place at the ground to address investments and investment-related disputes. Sajjad, may I please invite you first?
Thank you, Shan. That does hit a nerve in Pakistan as well. Investment arbitration, sort of a lightning rod. And I mentioned that, when Sika was launched too, one of the motivations was that, we need to stop this. We need to ensure this doesn't happen. And I think it stems from the lack of awareness, right? So I think you hit the nail on the head when you said that, you enter into an agreement, whether it's a multilateral convention or an international commercial investment agreement, you are, it's binding on you. You have to comply with every term, specifically the dispute resolution clause. So what has been happening in Pakistan, especially the past year, I've been involved with a couple of things as well. So the government is very gung-ho about reforming Pakistan's international investment law regime. So, and one of the things they're trying to do is come up with their own law, which actually contains a dispute resolution mechanism as well. So one of the things that they have proposed is a mechanism which has been adopted in Peru. And actually, I'm a big fan of that mechanism, and I think that's one of the recommendations I gave to them, whereby they have a government commission, which comprises several government officials, and they essentially, their job is to sort of nip it in the bud, to ensure that the dispute does not escalate in the first place, that, you know, the investors, they have a place to go to, a forum to go to, where they can discuss what is happening. You know, if it's a festering dispute, nip it in the bud. But I think that the problem with this particular bill, again, hasn't been enacted yet, is that, you know, they are being very ambitious. They even want to have domestic courts as adjudicating authorities for investment disputes. I don't think that is going to fly when it comes to foreign investors, but that's how ambitious they are. And I think, again, I think that the source is that resentment, in terms of international investment arbitral awards, especially a couple of the awards that were issued last year. So the point is, I don't think we're going to take that extreme view, because end of the day, we have to be part of this international global community, right? So we can't be isolated. So there are certain extreme steps, but I think there are some good propositions as well to reform the regime there. And again, very quickly, the model BIT is also being discussed. Frankly, I do not see much value in that and a lot of rationale in that, because end of the day, it comes down to bargaining power, right? So the developing world, the global south, so to speak, is still not have that power at the negotiating table, whereby they can say, take it or leave it, right? So I'm not sure, where that is coming from, but they're discussing that model BIT as well. But I think sometime later this year, we will learn officially about the model BIT and this new law that the government is talking about.
Thank you, Sajjad. Taihi, may I invite your views, please?
So Korea also has seen many ISDS cases recently. So the Korea-related investment treaty arbitrations have shown particularly rapid growth recently. Its first case involving Korea as a respondent state was filed in 2012. But to this date, a total of 12 ISDS cases have reportedly been filed against Korea, and 75% of them were initiated only recently, since 2018. And in 2018, there were 4 ISDS cases filed against Korea in 2018 only, topped only by Colombia with 6 cases and Spain with 5 cases. And also there have been 7 cases where Korea is a home state for claimant. So Korea has been quite relevant in the scene of ISDS as well. And the thing is, because of the cases that, where the Korea is involved as a respondent state, the public is not quite happy with the current situation. That the Korean people are quite not happy with the situation. So in response to this unfortunate to the public trend, a new permanent ISDS team was introduced in 2020 under the Ministry of Justice of Korea. So it is expected that Korean government's efforts for the current and potential ISDS cases will be comprehensive and streamlined to offer more centralized responses to investor-state disputes, or even preventive, as Mr. Sajjad said, even preventive to the cases or disputes being filed to the ISDS system. So that is the current situation of Korea relating to the ISDS.
Great.
If I could just jump in, sorry, Ishan, just to comment on that. I mean, that's an explosion in the last 2 years. I mean, from 2018 to today. So I think we're seeing this, and it's going to continue. Probably happened in Korea before it did in many other jurisdictions, but that's something that I think will continue, and it's going to spark this conversation about reform and how to make it, adequately tailored to the users and to the countries that are engaged in it. I think there used to be a time where countries would sign investment treaties as they thought it was sort of like a photo op. You know, you sign a treaty, you take a photo, and then years later they realize that these treaties have teeth. So it's something to engage in wisely.
Back in law school in the LLM year, you know, we were always shown this picture of that bipartisan picture of Clinton and the others signing the NAFTA. And perhaps, you know, it was that where they started thinking that it's a nice photo op. But then again, you know, if you're a developing country, you are bound to get into some trouble if something goes wrong, because that's how ISDS works. And it does have deep teeth, because one major award and it can affect and impact a lot of things. So coming to Victoria, would you like to share with us anything what's happening on ground in Hong Kong when speaking of ISDS, both in terms of HKIAC and your personal observation during your time there?
I would just want to briefly mention on Diogo point about the third-party funding that these amendments have been introduced in Hong Kong in 2017, became effective in 2019. So it's kind of recent, very positive development, and the same took place in Singapore. And so apart from the legislation that has been enacted in Hong Kong, HKC has also introduced amendments to the HKC rules requiring the party to disclose in writing that it is being funded. And what we see in HKC cases is the float currently is not huge. We have seen so far, I think, around 5 funded arbitrations. And the trend that we see is that the funding is used in respect of the huge claims. And I think the highest amount was around like $2 billion US dollars. And I also want to say that the third-party funding is not only used by impecunious parties, so it's also used by the parties that want to structure their financial risk in arbitrating. Therefore, we expect the growth of in the third-party funding cases in future after the in the post-pandemic world, when the things go back to normal. Also, I would, if I can, briefly respond to some questions from the audience, Ishan. May I? Yes,
by all means.
Yeah, I just briefly respond. So the first question that was addressed is what is the challenges the institution can face in virtual hearings? I would say from the HKC perspective that we issued our HKC virtual hearings guidelines, and from the institution perspectives, the challenges we see that the parties are equipped technologically differently. So this is the advice is to contact the institution as early as possible, and to arrange the testing to involve all of the parties in organizing the hearings, so the institution can provide with the necessary equipment, all of the parties and the tribunal. And this is, I think, I will echo all the presentation of the esteemed colleagues, that we see how the institutions remain flexible and respond quickly to the changes that COVID brought in order to address the needs of the parties and the tribunal. I would also would like to clarify that the slide which I showed on the interim measures arrangement, where it shows that the number of applicants around 75% are foreign applicants and around 28 are mainland Chinese applicants. I meant that the parties who apply for the interim measures arrangement from the PRC courts are mostly the foreign parties. So when they institute the proceedings against the mainland Chinese parties, this arrangement allowed them to preserve the, to seek the preservation of the assets owned by the mainland Chinese, which is respondent. But we also can see that the mainland Chinese parties also benefit from this arrangement, given that they also apply for interim relief from PRC court. And the last question that I see from our esteemed audience is what institution you see as the perfect institution for Belt and Road dispute. I think this is a very, this question depends on the exact circumstances of the case, and each dispute is unique. What I can say is that in the Belt and Road Initiative that was which was launched by the PRC in 2013, the main investor in all the project, the major part of investment is made by the mainland China. And in cases where the project involves the Chinese parties and non-Chinese parties, HKC can be the choice for the Chinese parties, as because of the Hong Kong, its geographical proximity, the cultural familiarity, and for the non-Chinese parties because the neutrality and independence of the seat and the institution is guaranteed, and also with the best international practices introduced in the services. But I think that, as I said, it depends on the specific circumstances of the case and the nationality of the parties and all the other details of the dispute. So I think
Victoria, if I can just chime in on that, that's absolutely correct. It will depend on the case. And of course, for a dispute that already exists, it's going to depend on the contract and whatever was agreed already. So, and I think from what I've seen is a lot of those documents have CIArb arbitration because China has pushed very hard for that. That said, I mean, as a practitioner, I would caution my clients not to get into a dispute with China in CIArb and to opt for institutions with a better, more established track record, such as HK, the Hong Kong International Arbitration Center, all the institutions we have here today, which could potentially provide a more neutral forum. So I think that, I mean, you see a lot of, whenever these things are negotiated, parties do push to have arbitrations in their home jurisdiction in a place that they control and that they're familiar with. And that's something that counterparties should be aware of and look to neutral offshore, quote unquote, jurisdictions that might be able to provide a little bit more neutrality and familiarity for both sides of the dispute.
Great, thank you. I think Belt and Road Initiative is something, on which you can have an independent series of webinars of panel discussions to discuss and know more about it, because there's so much to it, not just from the the idea perspective, but also from the political perspective that the stakeholders need to understand it much more depth. And for the audience who feel that we should be talking about it more, it's something that needs an independent discourse, which I believe we can structure in the near future. But coming back to Sajjad, please.
Yeah, so I have a question for the entire panel. So we're talking about emerging arbitration trends, right? So I think emerging arbitration trends are a function of the global economic trends as well, right? So if the global economy is developing in a certain way, how does that impact the choice of parties of the arbitral institutions? So for instance, people say this is the Asian century, the future is Asian, which of course has a lot of truth to it. So because of that, do you think that the choices of the parties, whether it's stipulation of a particular institution within their contracts, would shift eastward? And also, I think if you add the COVID-19 layer to that, the fact that, let's say, the global economy has grown more in, let's say, Asia, does that mean that because of the COVID-19, there's more financial distress experienced by the Asian countries, and because of that, the impact would again be on the arbitral institutions in Asia, like they would essentially be beneficiaries of that particular trend?
Diogo, I would rather ask you to answer that.
Yeah, no, I'm happy to come in. I think it's an excellent observation, Sajjad. I think without a doubt, I mean, the center of gravity is shifting from the Atlantic to the Pacific, right? I mean, we see that across the board, and I think that makes sense. And because of that, of course, you know, as that leverage changes, the institutions, the geographic location of institutions will change, the applicable law will change. In some cases, even the language of dispute could change, right? So all of these things will shift. As for COVID impacting developing economies worse, I mean, I think honestly that remains to be seen. I mean, you can see quite clearly that the United States has handled COVID much worse than many developing countries. So I don't think it's necessarily a linear connection between, you know, you'd say, I guess, level of development and how the impact, what the impact will be. But certainly, I think that, you know, this has hastened the use of technology, and in a way will facilitate smaller centers from the ability to establish themselves as things get remote and virtual, and the physical overhead requirements and those costs diminish. It will certainly level the playing field. So I think all of those factors work together very well to support new institutions, and particularly new institutions in Asia. And I guess the last point I'd also mention is, you know, Asian institutions are also coming to the West. So you have CIAC opening in New York. It's everything's getting mixed up, which in my opinion is a good thing when the world gets smaller. So.
And I think if you observe the trend, even the arbitration centers in Asia, there's more and more collaboration with the West. You have so many practitioners moving into arbitration centers in the East, acting as arbitrators, acting as counsel, and there's a lot of capacity building happening within those institutions. So I believe there's a trend that, I mean, a major part of the world's human capital actually lies in Asia. Just the two countries, India and China combined, are what, about a third of the world's population. And in terms of resources as well, I think because of the entire concept of party autonomy, whoever is able to provide a good service, a good setup, a good infrastructure, a good set of arbitrators, I believe those things, I mean, there are small factors, but they are still important factors. And of course, there are so many market dynamics involved. I don't see a reason why things do not or would not shift more and more to Asia.
And one other thing I'd like to mention also is that, I mean, we were actually, the panelists, we were speaking about the REAL presentation yesterday. It's a new initiative about diversity in arbitration. One thing I think that's inevitable is that the future thought leaders will be from Asia, will be Asians from Asia, not Western transplants to Singapore. That is, you know, as that leverage shifts, you're going to see that increasing diversity, and it won't be, you know, these minds from Europe or North America, but will actually be Indians, Bangladeshis, Koreans. You know, you'll have more of this homegrown thought leadership, and the future stars of the practice will be from Asia as well. So I think that's another point that we need to remember. And for any young practitioners from Asia listening to this, I mean, it's something that they should remember as well.
And I'll just chime in again. And before I also share the poll results, we were talking about arbitrability. And there's something that I've been excited about asking Tahi. Tahi, I read recently that arbitrability of IP disputes is something that's coming up. I mean, Korea is getting more and more famous for K-pop. The world is looking to Korea for music, for, you know, for partying, and then again there is so much intellectual property involved. So what's the development happening on that front?
So as you rightly mentioned, even the countries in Asian region are getting more relevant in the IP industry. As we can see from the report of WIPO, offices located in Asia account for around 2/3 of worldwide filing activity for IP rights in 2019. And besides the K-pop and K-film, the online gaming industry is also quite popular in Asia, including Korea, China, and Japan. So, so we see this growing industry, IP-related industry in Asia, and it naturally leads to more transactions in IP industry in Asia, which will naturally result in increase of disputes arising from such transactions. So Ishan, you mentioned the arbitrability of IP disputes. So the arbitrability of IP disputes has been the key issues involving IP arbitration, because creation, termination, and contents of IP rights are subject to national laws of a country that grants such rights. So it has been debated whether only a court of such a country has the exclusive jurisdiction to decide disputes over the IP rights, or it can be arbitrated. And the Asian countries have responded to the issue of arbitrability of IP disputes. For example, Hong Kong and Singapore have legislated to clarify explicitly in their arbitration laws that disputes relating to an IP issue can be arbitrated. And as to Korea, nothing is explicitly excluded by the Korean Arbitration Act as not being arbitrable. The 2016 amendments to Korean Arbitration Act broadened the scope of arbitrable disputes and included disputes over non-property rights as well. So basically, the countries, including those Asian countries that I mentioned, they are trying to address the arbitrability of IP disputes. And well, I found one interesting Korean Supreme Court case recently ruled in 2018, which stated that the possibility of arbitration in a particular dispute should not be restricted on a basis not universally recognized on an international level. So basically, the Korean Supreme Court allowed enforcement of a foreign arbitral award that had upheld a request based on a breach of a license agreement. One must note, however, that even if IP dispute is arbitrable under certain jurisdiction, the result of IP arbitration itself cannot cause any third-party effect, as an arbitration award binds the parties only. Well, another concern that has been raised regarding IP arbitration, besides the arbitrability of IP dispute itself, was the availability and enforceability of awards of injunctive relief. Oftentimes, injunctive relief is the only meaningful type of relief for IP rights holders, as for example, in a case involving counterfeit goods, the IP right holders' primary goal is often to obtain an injunction. So regarding that issue, the same Korean Supreme Court case I just mentioned is more noteworthy because in this case, a Netherlands company filed for an arbitration for breach of a license agreement when a counterpart Korean company had applied for a related patent after termination of the license agreement. The arbitral tribunal ordered the Korean company to pay indirect compulsory compensation should it not return all the rights and profits arising from the patent to the Netherlands company. The court allowed the enforcement of the award, accepting a lower court's decision that enforcing an award ordering indirect compulsory compensation is not in conflict with public order and morals of Korea. So according to this court decision, I think basically it is also possible that certain decision, I mean, the awards of injunctive relief can, in a way, to a certain extent, can be enforced in national court of Korea. That is my view. And so that summed up the arbitrability issues or some issues relating to IP arbitration. And if I may, I'd like to introduce one arbitration case administered by Kcab International involving Asian game companies. This case was already reported publicly, so you can Google it. So the dispute arose from a license agreement, software license agreement concerning a popular online game, and the dispute amount was huge. It was over $1 billion US. So the Korean company, a Korean company filed an arbitration against a Chinese company, arguing the Chinese company had breached a software license agreement by, among others, not making a payment of royalties. Then the arbitrary tribunal ordered the latter, the Chinese company, to compensate the Korean company. What I find interesting about this case is that there have also been two related other arbitration cases administered by ICC and CIArb respectively, involving the same online game series. And this, I believe, signifies that IP arbitration has a potential to rise significantly, as one patent or copyright can be filed in several different jurisdictions across the globe as information technology keeps evolving. And that's all I've got to say. Thank you.
Thank you, Tahi. Just one question. I mean, there's also this recent trend, and of course, India has been involved on that front also, about emergency arbitration awards. I'm sure there are several institutions that provide for such facilities, that provide for an emergency constitution and emergency arbitration. But speaking on the ground, and Diogo, from a more diverse perspective, how do you look at the enforcement of emergency arbitration awards?
Well, I think Tahi, as he mentioned, I mean, the emergency arbitration awards can be essential in terms of getting injunctive relief early on in a dispute. So, for example, if the the assets that are being argued about might have a chance of leaving the relevant jurisdictions, to freeze things, those emergency orders are essential. Now, I mean, the key question I would see with that is obviously the law applicable to the seat. So it really depends where your arbitration is seated to see what kind of abilities you'll have, and of course also the law where in the jurisdiction where the assets are located or where the emergency measures are going to be implemented. So I mean, that's really a complex question that will depend on a case-to-case analysis. I think arbitral institutions have done a great job, not just in Asia but around the world. I mean, the ICC, the LCIA have been making a lot of progress in their procedures for emergency arbitrator decisions. So that's something that is essential. And as Tahi mentioned, those sorts of injunctive or preliminary measures can be the entirety of a dispute. Without that, sometimes a plaintiff will have no recourse at all. So I'm not sure if that answers it. It ends up being very case by case in the end.
It does eventually. So what I wish to do before, I mean, we do have some minutes left. What I wish to do before we close in is to share the results of the poll and perhaps go in the reverse order from which I started sharing the questions. So I'm just going to share the questions so that we understand what the audiences think, and of course, to collate this data and prepare a comparative study as we move along from region to region and continent to continent. So the last question that we asked was, what barriers exist which currently prevent access to justice? Now, when we are talking about emerging trends in arbitration in Asia, we're going to discuss the same issue in more regions and continents. We are also understanding things that are happening domestically. It's not just about international dispute resolution, it's about ADR as a whole. And of course, things have to be fixed at a domestic level for them to work well at an international level as well. So, of course, one of the major issues remains cost to users, which, of course, like efforts being made by Sujad and Mr. Azad for capacity building. And I think as these things evolve, it's going to create avenues for more access to justice. And now if we move to our other question in terms of effectiveness. I believe you can all see the questions, right? The poll results. So yeah, so
Yes.
what dispute resolution framework is most effective in referring disputes to ADR? And well, that is where our concept of party autonomy comes in finally. And it's very important, again, to understand party autonomy because everything rests on that. And from my understanding, it's what I figured that a lot of people, especially in the business community, they fail to understand the concept of party autonomy, and things do get or begin to or tend to deviate there. Moving on to our next result, that's about what pandemic adjustments have been made to accommodate parties in dispute. And of course, I think this has been the single major thing that has been done, and especially thanks to Victoria's stats, they clearly show how much online dispute resolution or virtual hearings and the facilities being meted out there are going to make a difference. Sajjad, I might want to invite you here. You spoke about ODR, you spoke about online dispute resolution, but how do you see that becoming a reality in Pakistan? And perhaps from your experience, if you could share how online dispute resolutions from scratch, from the beginning to the end, can actually become a working reality.
Yeah, I think like anything new, I think it takes a while for people to be sort of open to the idea and embrace it. There's been a lot of talk about the importance of technology, but frankly, I mean, we haven't seen sort of the needle move that much on that. And I think part of the reason for that is I think people are just used to, going to court, adopting the traditional methods. So although technology makes things very convenient and cost efficient, but I think it's still sort of early days. It's still sort of early to assess how much of an impact it can have. I think it holds a lot of promise, but so far we haven't seen an overwhelming response, so to speak. I think in due course, I think that will change.
Thank you. Speaking of the benefits, and what are the most pronounced benefits of ADR in playing during the pandemic? And of course, the most important thing, or rather, it's just a 1% difference in the answers. It's cost effective and of course, timely access to justice. So what we've been discussing here in the central organizing group and talking about the future of ADR, we have to go beyond arbitration. And that's what my next question that I'm going to share is going to look like, that it's not just about arbitration. There is mediation, there is negotiation, there are other dispute adjudication fora which have to be explored, and perhaps in the time to come there's going to be an uptick in other alternative mechanisms as well. This was the first question that we asked, that what dispute resolution fora is most prevalent during the pandemic. Remains arbitration, but 55% of the audience shared that it is mediation. And just speaking on that mediation, the next event, which is going to happen in less than 12 hours from now, is going to be about mediation and arbitration and the Singapore Convention. So do tune in to understand more on that, and we will have Kirsten Teo moderating that session. So these were more or less the poll results, and something that I wished to share with the audience because of the views shared by them. That's going to help us. But I in fact open the stage to all the speakers to please chime in with anything you wish to talk about in terms of the discussions that we've had and something that you feel that we missed out on covering. And I please request you all to unmute yourselves. Victoria, any closing words from your side, please?
I would just want to say that the panel that we have today, I think, is also kind of demonstrate of one of the trend, not only in Asia, but I think around the world, is what we call the cross-institutional sharing of knowledge, and which is, I think, very important, especially in the times when we have new challenges, and with the advice, or I would say consultancy with the private practitioners, as Diogo participating with us today. So I think this is what I can conclude on our panel, that it's represent this kind of development, and I'm very happy to have listened to all the views. So thank you very much.
Thank you, Victoria. Mr. Azad. Oh, sorry, Sajjad, please.
Yeah, so a wise man once said, the future belongs to those who create it. Right? So it's very deep. So my point is that we talk about emerging trends, what the future of arbitration is. I think it's going to be a very level playing field in the future. I think this refers to what Diogo said as well. Things are changing at a very fast pace. It's not just because of the COVID-19. I think it's global economic trends as well. So I think whether it's arbitral institution, whether it's arbitrators, arbitration council, ADR practitioners, I think the future is going to belong to those who will sort of step up to the plate and basically have the credentials to do a good job. So I think it's not going to be the color of your skin, your nationality, or your race. I think it's going to depend essentially on your credentials, and it's going to be very meritocratic setup. That's what I think.
Thank you. Mr. Azad. Mr. Azad, you're on mute. Yeah.
Yes, thank you. As you know that in England, it is mandatory to exhaust ADR proceedings in 100% cases before going to the courts. Let's try to convince our governments for updating legislations to incorporate mandatory ADR provisions so that things can be tried, at least tried as a matter of must, not ifs and buts, options to be or not to be. There should be a provision as a must to decide out of court before going to the court. If that regulation is made throughout Asia, I think there will be minimization of cases, backlog of case dockets will be minimized, dispensation of justice will be easier, and commercial disputes will be much less, and speedy disposal will be possible. Because once you follow the court-directed alternative dispute resolution, and if you fail, it tantamounts to an additional dispute resolution procedure. But if it is guided in the law that you have to adhere to the alternative dispute resolution before going to the court, and if it is resolved there, you may not have to go to the court at all. So let's try. Let's work together from that point of view. That is my proposal.
And we are hopeful that with the efforts you're making, I'm pretty sure a breakthrough is on the cards, and a lot of shackles will be broken, and ADR will become a living reality in Bangladesh. So congratulations to you for the great work and your contributions. Taihi, please, if I may just invite you quickly for your closing words on this.
So nothing. I have nothing much to add to what my colleagues have said, but I really enjoyed to have an overview of emerging arbitration trends in Asia from perspectives of different regions in the Asia. And well, I think ADR in general has a significant potential to contribute to goodness to the global world. Yeah.
Thank you, Tahi. And Diogo, please, some closing words from your end.
I mean, just to echo what we've already heard, I mean, this was a real pleasure. And as Sajjad said, I mean, the future belongs to those who make it and take action. So I'd like to thank Kcab and Cardozo for sponsoring this, and all the other sponsors, and thank you, Ishan, for moderating. It was a real pleasure. And for what it's worth, I mean, this is a great conversation. If anybody wants to follow up and send me an email, I think I sent it out in the comments and it's available online. I'd be delighted to continue this conversation with all of you. So thank you very much.
That's amazing. Thank you so much, Diogo. I'll just go back to Victoria's words when she mentioned that, this is institutional support. And I think these exercises are important because, this is exactly what Sajad was mentioning when he was looking at things back in 2015, that there is need for capacity building. And there's need for capacity building, not just at the domestic level, there's need for capacity building at regional levels, at continental levels, and of course at a global level. It's not about creating competition that, one arbitration center pops up here and the other pops up there. It's more about enabling more and more institutions and practitioners to come in and provide avenues, because we've all seen through this pandemic that perhaps arbitration is going to be more effective and perhaps we can burden courts less. I'm just talking about in a domestic scenario. Perhaps courts can be burdened less with only just the enforcement of awards rather than undergoing the entire process of adjudication of claims. And of course, once things begin to function there is so much scope for swifter, speedier international dispute resolution. And of course, as we are talking about ADR as a force for good. So with that, I'm so glad and so grateful that I had a great time listening to all of you. I am so grateful that all of you made out time to talk about your respective institutions, your perspectives, sharing information of what's happening on the ground, and of course, perspectives from outside the region. So thank you so much. Thank you so much for being part of this inaugural event of the Chartered Institute of Arbitrators YMG ADR World Tour. And this is just the first of the many events that we wish to have. The series, again, is going to run from January to April. We're going to cover 11 regions and continents with speakers, arbitration institutions, academicians, professors, students from all across the world. And together, we are actually carrying out this exercise of capacity building and promoting ADR as a force for good. You will all be receiving soon follow-up emails. We will try our best to add within those emails the recorded video of this event. And we look forward to your participation in exactly 11 and a half hours from now, as we move to the second event of this Asia series, which is going to be Med, moderated by Kirsten Teo. You all would have seen the flyers, and we look forward to seeing you there.